Hi, my name is Robert Shelley with Chelle Law, and my firm assists physicians with employment contract issues. One fairly frequent question that I get, mostly from people coming out of training, is what happens if I sign an offer letter, but I don't want to go through with signing the actual contract? Maybe due to a change in circumstances, some kind of family issue. Maybe you got a better job offer somewhere else. Maybe you decided to move home instead of moving to a different city. So basically, the question is, can a physician back out after signing an offer letter? The short answer is yes, probably. Um, Unless there's some kind of binding language in the offer letter, which there almost never would be, the physician can back out. The offer letter just has kind of basic terms. So normally it would be like, okay, here's what your compensation is, maybe a brief review of benefits, the term length, maybe how to terminate the contract, maybe a brief mention of non-compete. It is, normally like one-page document that just kind of briefly goes over, here's what it's going to look like for your employment. There are times where I'll have a physician get an offer letter and, they're just the kind of cursory terms look great. And then when we get the actual agreement, it could absolutely change whether it's a good offer or not. And so until the employment agreement is signed, it's not going to be a binding document for that reason. So let me give some instances of maybe why it looked okay. The job opportunity looked okay with the offer letter, but once we got the actual employment agreement, it changed. So one thing could be how to terminate the agreement. I would say it's probably rarely put into an offer letter, but let's say normally a physician would have to provide either 60 or 90 days notice to terminate the contract without cause, meaning they can kind of get out of the agreement for any reason that with the amount of required notice. Let's say the contract had a 12-month without cause termination notice. Well, nobody wants that, right? Once you give notice, relationships change within the organization. You're on your way out. You're no longer building a practice. And so if someone has a 12-month requirement, to be an entire year of potential kind of awkward relationships. And I would never suggest that a physician would have to give a year's notice. On the back end of that, if you're currently in practice and you have to give 12 months notice, there are very few practices that are willing to wait 12 months for the physician to give notice and be able to leave. It just doesn't happen that way. Sometimes if a physician's in training, and an organization has forecast that they will be needed a year or two down the line, that's a different story. But if a physician is currently practicing and switching to a new job, they're almost never going to wait 12 months. Another thing could be the terms of the non-compete. So maybe you're expecting a reasonable non-compete, maybe like 1 year, 10 miles from your primary practice location. Non-competes, kind of the reasonableness of non-competes varies state to state. It's pretty much like one of the only things that kind of varies in physician contracts. But let's just say, for instance, it's 1 year, 5 to 10 miles from your primary practice location. That's what you're expecting. And then you get the contract and it's a 2-year non-compete and 25 miles from every location that you practice in while employed with the employer. That can change things substantially. If someone is absolutely married to a town, like they grew up there, family's there, they want to raise their kids there, and then they have some absolutely terrible non-compete, which would essentially force them to move for a period of time, that can make a great offer a terrible offer. And so that's an essential term that could change, that's not spelled out in the offer letter, that could then make a great offer a bad offer. Benefits as well. Generally, there's not specific, recitation of all the benefits that are offered. What if the employer doesn't offer health coverage or disability or life or retirement. They won't pay for your medical license and DEA registration. They won't give you anything for continuing medical education. Perhaps the time off, is bad. Like an average amount of total time off is 30 days. So that would include sick days, holidays, vacation, CME. Let's say they offer you 15 total days. I mean, almost no physician has that small amount of time off. And so that could change substantially whether the offer is good or bad. So in short, yes, you do not have to go forward, even if you've signed an offer letter, because the terms of the employment agreement could change the offer substantially. It can start in awkward conversations. And the sooner that you give notice to the employer that you are not going to start, the better. So people also ask, all right, well, what could be like the absolute worst case scenario? Well, in this case, if it's just an offer letter, I would say it's a pretty low downside risk. Obviously, if you sign an employment agreement and then wait until a week before you're about to start and then say, hey, I don't want to start the contract, well, the employer can certainly say that they've suffered some damages and potentially could come after you for that. If you've just signed the offer letter without even seeing the employment agreement, I'd say that the physician is fairly safe in backing out of it and looking elsewhere. I hope that was helpful. If you have any questions, you can call us at the number listed below in the description, or you can reach us through our website, chellelaw.com. That's CHELLE law.com. And appreciate you watching the video. Thanks.